The Checkpoint is presented by GM Pharma, the first international multinational pharmaceutical company in Georgia. GM Pharma, to serve those who need it most.
How related are competition and the well-being of a country? What should Georgia do to ensure the enforcement of consumer protection laws? How efficient is the National Competitional Agency of Georgia? These are some of the questions that our analyst Georgy Aronia discussed with the head of competition and consumer policies at the United Nations Conference on Trade and Development, Teresa Moreira.
Ms. Moreira, thank you for being with us today.
My pleasure.
Look, the first question I want to ask you is very global. What is the situation in the world right now in terms of limitation of competition and abuse of power by the marketplaces, by the people involved here? Well, what could you tell me about this?
Well, I think there are clear trends, especially since the pandemic outbreak. So I would say for the last 2.5 years, which come from the rising power of big tech. So digital platforms really became indispensable for all of us as consumers or as businesses because of the lockdown situation. And we are not seeing consumers or businesses going back to previous habits, on the other way around, I would say, across the world. This, of course, allowed these big tech players to enhance their already considerable market power through a number of mergers and acquisitions, often under the radar of competition authorities, because they may be of startups or young, innovative firms. And what we are seeing is that global players, despite being global, they look at the world as a single market, but they do not abide by data protection of consumers or by consumer rights across the world. So this is clearly a trend and a challenge. So digital markets raise concerns both from the competition and the consumer protection side. It is extremely important that competition authorities and consumer protection agencies are able to exchange information, knowledge, experience, explore, when possible, collaboration or joint activities, so that these abusive or unfair behaviors are flagged in time for them to act. One thing that I want to mention that I believe it's an interesting development is that already pre-pandemic, a number of competition authorities, even of developing countries, started exploring interactive tools to identify cartels, to flag abusive behavior. And that is an interesting use of technology. So of course, big tech are on the rise, but let's say competition and consumer protection enforcers can also make the most out of technology to be better equipped. At the same time, we have noticed that competition authorities across the world are investing in data analytics, which became, let's say, the biggest issue at stake, because they need to understand how these new business models work before they start forbidding behavior or imposing sanctions.
Big part of the success of the competition law in general comes to enforcement. How do you envision what should be done and what should Georgia do because for our country this is a relatively new field, what should we do to ensure that the laws are enforced properly and so that no one abuses the power that they have?
That is a very interesting question. Yes, I do believe that it is important to have a legal and institutional framework, as you have in Georgia already for some years. So I believe competition law was enacted in 2014. Of course, everywhere, even in the most developed countries, it takes a while for a competition authority to assert itself. It is very important to enforce the law respecting due process, so allowing for the rights of defense of businesses, and to make sure in a way that your decisions are sound and can be confirmed by judicial control, which usually is also in place. Why is this important? Because only after a competition authority has demonstrated its enforcement capacity can then the authority have open a dialogue with business in order to prevent abusive behavior or anti-competitive practices, or in order to discuss possible commitments or remedies, namely in merger cases. But for this dialogue to be effective, the authority needs to be respected, needs to be considered. And this only comes after law enforcement. So it is a process. It usually takes some time because investigations are long. Again, you need, in a way, to be generating public support. Why am I mentioning this? Because this is something that is very important for any competition authority. You need to be able to generate public support. And this means to say that you need to explain the society, so of course the market, but also society, why competition is beneficial, what is there to gain, and at the same time, you need to explain and engage your stakeholders in the process, so that, you know, if you are doing an inspection on site, a business premises, this is understood as an investigative tool to gather relevant information, but not necessarily an intrusive measure. And also with the judiciary, when they need to authorize, for instance, they need to issue warrants for this type of inspections to take place, they need to understand in advance what this is all about. Because usually, typically inspections and things like that were reserved for major infringements of criminal nature, you see. So you need to, while you are enforcing law, you need to be raising awareness, informing, advocating for competition in your market, in your society, with your counterparts and stakeholders. And this takes time. And at the same time, it needs to continue. It's not just because the agency has had, let's say, 5 very successful decisions that are confirmed by courts that you can relax and think, oh, now everybody knows what I do and why we do it. You still need to be concerned about that to get this public support. So it is a process.
You know, for Georgia, we are in a odd situation right now because in general, our legal system is heading towards European harmonization. You know, and given this context and given the fact that the competition agency and the business is a relatively new phenomenon here, there might be some sort of dual problem. You know, how do we we ensure the development of the independent system, and then we have to harmonize it with the European system in a way. So what your advices would be to the national agency?
I think that is also an important point, but I think let's say the good news, so to speak, is that a lot of countries have been through that process, and I have observed in my past experience how joining the EU and harmonizing the EU allowed for an enhancement of the competition of competition law and policy in the country, and how much was offered by the cooperation with other European member states and European competition authorities. I think the positive side of this is that because of your country's views towards the EU, there is a strong encouragement to follow, I would say, frankly, the state-of-the-art best practices, even when they are a little bit how can I put it, demanding vis-a-vis some sectors of economic activity or some businesses. But this has happened, I think, in a lot of countries that have joined the EU in the past 30 years. This is a stimulus. And I think, again, what is important is to explain to the private sector that these requirements, which may sometimes seem burdensome or not understandable, will allow them to have access to the biggest single market in the world, and where, of course, where all businesses have opportunities, but also where consumers tend to be quite demanding because they are used to have very wide choice, very good quality, very good prices. But this is really a stimulus for economic activities to flourish, even though the process can be a hard one. But I do believe that it is important to explain this to businesses according, let's say, to the language used in markets, and not just through invoking legislation or international law provisions, because that does not necessarily make the deal. And I have seen that throughout the world, you need to adjust your language according to the audience interests, needs, and expectations. You cannot talk to an expert in a public body the same way that you talk to a small somebody who has a family business and who can legitimately ask, why now do I have to organize everything differently? You see, what's in it for me? And the competition authority needs to be able to explain this. I believe that in Georgia, the competition system already has embedded a number of key issues that are fully compliant with the European competition law, to go back to competition. Therefore, I don't think that is a major challenge. For instance, the recent legal amendments already reflected a number of key issues that are important for the EU and other developed countries. So that, I think that is the process. Of course, the interesting part was to explain, and I had the privilege of being a little bit involved in that in 2017, to explain to members of parliament and even to interact with ministers to really confirm how important and why some amendments were necessary or relevant. But I do believe that you are in the right track.
As you just mentioned, you visited Georgia back in 2017. Based on your experience back then and on your experience now, as I know you've met with the chairman of the Georgian National Agency of Competition, how would you rate their willingness, their political will, their capabilities, and do we have, as a country, do we have enough tools and willpower to push the consumer protection reform through?
Well, I was very impressed with the amendments, because I can tell you, it is frequent that authorities identify areas for improvement in the legal and institutional framework. It's not a given that the government and parliament will agree with these amendments. So I think in a rather short period of time, and even throughout the pandemic, a major global pandemic, in Georgia you were able to amend the law. I think it was very interesting. It was very interesting to add this new mandate on consumer protection. I do believe that is very modern, I should say. So you see, that is the advantage of a lot of developing countries or economies in transition, is that you can leapfrog. You do not need to go through the process of anybody else, and you do it your own way, according to your own priorities, which is the right way. I was very impressed also with what I heard about the close cooperation with sector-specific regulators. I should tell you that that is not a given, even in several developed countries. I think definitely sectors like energy, telecommunications, and the financial services these are key issues, both for markets, so for businesses and for consumers, because everybody needs energy to produce in a plant, or you need telecommunications to do your business online or in other forms. As a consumer, we are also dependent on these services, and of course, and banking services and payments and insurance are essential for people's and businesses' lives. So I was very impressed with that. I think it also sends a very powerful message to the market, you see, that there is this collaboration, that business cannot just knock on each of the regulator's door and with a different story, because they will be caught, let's say, if they try a different approach. I think that is very reassuring also for consumers, that there is this collaboration and that there is this network that can really pursue competitive markets that work for consumers in the best possible manner. So I'm really impressed, and I think that's why I suggested that the regulators and the agency, who of course comes to my intergovernmental meetings in Geneva, that come and share this experience. So I think you are in the right track. Now, having said this, you still have, like everybody, work ahead to fully assert competition law and policy. I'm not fully aware of the current economic situation details in Georgia, but what I mentioned earlier in my intervention, that with the pandemic we saw a rise of state intervention in the economy, you know, the launch of economic recovery packages, and that runs the risk of unbalancing markets, of privileging some companies according to discriminatory and non-transparent conditions, and of creating a sort of fixed structure in markets. And it's very important that the competition authority and the regulators are extremely attentive. And so doing competition advocacy used to be considered a sort of complementary task of competition authorities, but it's clear that it is as important as law enforcement, because in a lot of countries across the world, public restraints in markets are a serious cause of lack of competition. So it is important that the competition authority and the sector regulators also work together in improving the enabling business environment. And this is essential also for investors to come, because you need to have a predictability. You need to have predictability. You need to have a stable environment to come and invest. And this is essential for a country that is growing like your own.
Well, thank you very much for your time. It's a pleasure.
It was a pleasure. Thank you.
The Checkpoint is presented by GM Pharma, the first international multinational pharmaceutical company in Georgia. GM Pharma, to serve those who need it most.